Welcome to Open Minds, a freedom of thought podcast series, interviewing the people who bring courage and independent thought to the challenges of today.
First, let's start with your scholarship. So, is there an article you've written that you're the most proud of? And if not, I have a couple specific ones I want to ask about.
Yeah.
I thought I would just give you a chance to tell us,
I mean,
trundle out the heavy artillery of
like,
constitutional law is the best line I've ever seen in a law review article.
Which line's that?
Trundle out the heavy artillery of constitutional law. I never heard the word trundle. I thought that was really nice. I don't even remember which article that was.
I think I came from the Murdoch article.
Yeah,
that was a long time ago. So, pride is not something I aspire to, but when I think about scholarship and what role it should play, I want it to, part of it is to challenge the conventional wisdom, try to get people thinking about ideas that have been, I think, for too long unchallenged, and if possible, change people's way of thinking if you're right. With scholarship, you don't necessarily have to be right, you just have to be interesting. And you're trying to contribute to knowledge and eventually the development of law just by putting ideas out there and having them tested. So it's hard to answer your question right now because I don't know what these articles will lead to in the end. I think we're still seeing ideas play out from the writ of erasure.
Well, let me ask about two that I think that's probably your most influential article, and I have some questions about that. Let me ask you before that, though, about another one that is very interesting, particularly in light of last term, which is textualism in the 14th Amendment. So, as I understand it, but you should obviously say, your argument is that equal protection has gotten way afield from what the Constitution actually provides. So maybe you could just talk about the central thesis of that.
I mean, right now, equal protection doctrine is almost exclusively about judicial precedent. The text isn't even mentioned. When you see the Supreme Court, even the recent Harvard decision from last term, I don't think the text of the Equal Protection Clause was quoted in the Chief's opinion. It certainly wasn't applied to the particular facts. And the Chief talks about equal protection all the way through, even though Harvard isn't even subject to the Equal Protection Clause. Now, I think what he meant to say is equal protection means the same thing as Title VI, so he was using that as shorthand. I'm not trying to say. I'm sure the Chief Justice knows the Equal Protection Clause doesn't apply to private universities. But I would have preferred to see the opinion be more focused on the text. And it wasn't. It was all about doctrine. Everything was about precedent, how we interpreted the Equal Protection Clause over time.
And what is the text, and what does it actually mean?
No state shall deny to any person within its jurisdiction the equal protection of the laws. I mean, right away, when you think about affirmative action in college admissions at the University of North Carolina, are the applicants from out of state within the jurisdiction of North Carolina when they submit an application to the university over email? It's not clear to me that they are. What about that? No one even addressed that textual point. And if I were defending the university, that would have been one of my lead arguments. You say we're violating the Equal Protection Clause. Can we begin by...
Seth Waxman didn't think of that, I guess.
Well, no, I don't blame Seth Waxman for not making the argument because even the so-called textualists on our Supreme Court right now will, on occasion, ignore the text. And equal protection is one of the areas in which they've done so. So one of the goals of that article was to try to construct a theory of the 14th Amendment, specifically the Equal Protection Clause, that was grounded in text and enable textualist jurists to move away from the precedent-based reasoning that we see so often, even from so-called conservative judges in these equal protection cases.
So do you think the court got it wrong in Students for Fair Admissions?
No, I think the case was rightly decided, but I would have decided it solely on the text of Title VI.
Say a little more about that.
Well, there's a federal statute that says if you receive federal funds, and both Harvard and the University of North Carolina receive federal funds, you can't discriminate based on race. That's clear, unambiguous. There's no exception in the statute for compelling interests. There's no exception in the statute for affirmative action. There's no exception for any of these court-created ideas that show up in the equal protection case law. I just would have said open and shut. This is a violation of Title VI. If you want to continue your affirmative action programs, turn down the federal money.
So what would you do with situations where there's racial discrimination but no statute like Title VI? And I'll use contracting as an example. There may be a statute, I don't know. But like federal contracting, and so there's a federal statute that says, BIPOC businesses get half the contracts or something.
Right.
Adirondack contractors, I guess, already said that that's not constitutional, but is that right?
Well, thankfully, we do have a federal statute dealing with contracting. Okay, it's Section 1981. It's part of the Civil Rights Act of 1866. Yes. Almost every state now has explicit bans on racial discrimination in their codified law that apply to employment, that apply to public accommodations.
You would leave it to that, and if there's not a statute,
Well, I mean, that's what the Supreme Court has said so many times. If we don't need to reach a constitutional question, don't reach it. When there's a statutory ground on which to resolve the case, resolve it on the statutory ground. They say this all the time. I mean, they didn't follow their advice in the university affirmative action cases. But why reach out to decide a constitutional question when there's a statute that's up to the task?
I think it's a good question. So now let's talk about the writ of erasure fallacy, because I love the article. You know it's a great article because it makes a point that everyone feels like they already knew, but no one had ever actually said, which to me is sort of an indication of a great insight. Could you just kind of talk about what the article says, and people may not be familiar with it, and just kind of explain what you argue?
Sure. Yeah, in a nutshell, there's been so much rhetoric we use to describe judicial review that implies that the Supreme Court and the federal judiciary have a veto-like power over legislation. So when you pick up a newspaper, it will say the Supreme Court strikes down such and such a law, or the Supreme Court blocks such and such a law, or federal district court blocks or strikes down or invalidates. This type of language suggests that courts are acting on the statute itself, and they have no power to do that. Courts can only act on litigants who have been sued and named as defendants in the lawsuit. So the courts will perhaps issue an injunction that tells an officer not to enforce the statute, but they don't block the statute itself from taking effect, even though we use language suggesting that they do. So one goal of the article was to just call out this fallacious use of what was, in my view, sloppy nomenclature, but also to explore the implications of what happens when we properly understand judicial review as a power that operates on litigants and not on statutes. So some of the ideas in that article created the framework for Senate Bill 8, the Heartbeat Act that we talked about earlier, because we crafted that law in a way to make it impossible for the courts to do anything about pre-enforcement, because there was no officer of the state charged with enforcing the law. We actually put a provision in there that explicitly banned state officials from enforcing the Texas Heartbeat Act and said it can only be enforced through private civil lawsuits. So there really was no one to sue, and without anyone to sue, there's nothing the courts can do in terms of judicial review until somebody violates the statute and gets sued in state court for the violation. At that point, they can assert the constitutional claims as a defense, in a defensive posture. So
one thought I had as I was getting ready for this is, the court has spent a lot of time fighting about severability, and what you do. So for Obamacare, the first Obamacare case is a good example where the mandate was unconstitutional, and there was a big fight about what that meant for the rest of the act.
Right.
Under the writ of erasure fallacy, what would your view be? Just that the unconstitutional provision cannot be enforced by the courts, or how would you deal with severability?
Yeah. So I'd have to see exactly how the lawsuit is phrased and what's brought and what provisions are being invoked. There's really no such thing as challenging a statute. I mean, that's another rhetorical device I think we need to get rid of. When you sue and argue that a statute is unconstitutional, you are challenging the behavior of the named defendant that you have sued. You're not challenging the law itself. You don't sue the statute, right? And you can't seek a remedy against the statute. You're seeking a remedy against the officer, or maybe sometimes it's the government, if you can sue the state or the United States of America. So if we go back to the first Obamacare case, I believe Secretary Sebelius was the defendant. So the injunction should be directed at the secretary, and it should tell her not to enforce the provisions of the law that would result in a violation of the Constitution. I don't know how you can justify a remedy that would tell her not to enforce a statutory provision if her actions in enforcing a separate statutory provision wouldn't violate the Constitution.
So you would say the four-justice dissent was mistaken to suggest that the whole act must fall because the mandate was non-enforceable.
I thought that was crazy. And when you say the whole act must fall, that sounds like the writ of erasure fallacy.
Well, I think they wrote this before your article, so they didn't know.
But the act doesn't fall,
but that was
right?
the upshot of the dissent.
Yeah, you're issuing an injunction, and the question is, what should the injunction say? And the injunction should be written in a way to provide the relief against the alleged constitutional violation, which would be an unconstitutional action of the state official or the federal official that you sued in that particular case. You don't issue a remedy against the statute.
Right, so you would enjoin the mandate, and then that's it.
Well, no, I wouldn't enjoin. Don't say enjoin the mandate, right? You enjoin. It's okay. You enjoin the secretary. You never enjoin a law, right? We still see this rhetoric cropping up in Supreme Court opinions all the time.
We should send a copy of your article every year.
I don't know. It's even the justices who have cited my article will still use this rhetoric in their opinions. I mean, Justice Gorsuch uses the phrase "struck down" more than any other justice. It drives me crazy. But
I'll talk to him about it.
Okay.
So actually, speaking of Justice Gorsuch, so the term I clerked, the court decided Collins against Yellen.
Oh, yeah.
And just for those who don't know, basically the issue was the federal home loan mortgage corporation's director had a removal protection. So the president, under the statute, the president could not remove him but for cause. That's the basic issue. And so there they said that was unconstitutional, that the removal protection, could not be enforced. And so then there was a big fight about what that means. And the majority basically punted and said,
right.
It probably doesn't mean anything. Justice Thomas, who I think, thought he was applying the writ of erasure fallacy wisdom correctly, said that basically that provision had never been in existence, that it had always been trumped by the higher authority of the Constitution. Justice Gorsuch disagreed with him, and it's a fun two dueling opinions, where Justice Gorsuch said, no, that's not the right way to think about it. What the officer did should be enjoined, or in that case vacated,
right.
because the officer was operating in an unconstitutionally structured scheme. And so I'm just wondering, if the gospel of the writ of erasure fallacy is being applied correctly, or what you would say about this.
So that's hard. The court didn't reach the remedial question.
Well, the Gorsuch
right?
and Thomas.
They were
That's
concurring.
The most interesting.
So these two concurring opinions were fighting over what the remedy should be. Had the court
Justice
resolved
Thomas
it.
said no remedy because this provision never had any force. Justice Gorsuch said, what are you talking about? Everybody thought this guy was only removable for cause. And that had all sorts of practical consequences for the real world. And so his actions were ultra-virus, just as if he'd been improperly appointed.
Do you remember, was this lawsuit brought under the APA, or was it brought under...
That I do not remember.
So this is where things would get very interesting with the APA, because if you're bringing an APA challenge to an agency action, so the Administrative Procedure Act does allow you to sue over allegedly unlawful agency action, and Section 706 allows courts to hold unlawful and set aside agency action that's not in accordance with law. So you actually have a statute authorizing a court to act directly on the agency action, which would be a rule. This was an agency rule that was being challenged, right? Not a statute.
Yeah.
So a very different issue there. That's an agency rule. It's not a statute enacted by Congress or by a state legislature. And you have the APA that specifically authorizes an erasure type remedy, in the sense that you can act directly on the action. You can act directly on the rule by holding it unlawful and setting it aside. Now, what does setting aside mean? There's some debate over that. We saw this in the recent case, United States against Texas last term. Some people have thought set aside means formally vacate, veto, essentially, the agency rule. Justice Gorsuch actually disputed that, and so has Professor Harrison. So, interesting question there. All that's to say, I don't take a position on the writ of erasure fallacy about what the remedy should be in the particular situation you described. It's a much more complicated question when you're dealing with agency rules, because we have a statute that specifically authorizes something that seems to look like an erasure type remedy, which you can never do with a statute.
Speaking of that, another issue that was a big issue in the Trump administration and continues today is nationwide remedies, nationwide injunctions. I'm sure, do you have any thoughts on that?
Yeah, I sure do. I mean,
I assumed.
What we see, especially in the Trump administration, we're seeing it now, we see district court judges giving out universal remedies like candy. And they almost assume in the district court that once you come in and establish the illegality of an executive action or illegality or unconstitutionality of a statute, that they can issue a remedy that enjoins the executive from enforcing against anybody and not just the plaintiff. That to me is a manifestation of the writ of erasure mindset, because they're thinking to themselves, this rule is unconstitutional, or this executive order is unconstitutional or illegal, therefore I'm going to issue a remedy that pretends that I have the power to erase it. You don't, right? Your only power in a case between litigants is to issue a remedy that restrains the executive from enforcing it against that guy. Now, if that person wants to bring it as a class action lawsuit and get a certified class, go ahead and do that. But without the certified class, you have no basis for seeking relief on behalf of a class that hasn't been certified yet. You're just getting around Rule 23.
It obviates the entire existence of an injunctive class.
Yeah, what do we need? Right, exactly. What do we need Rule 23b2 for, right? When you can just issue a universal remedy willy-nilly. So part of that, but I do think the mindset of the idea that the universal remedy can just be issued without any analysis comes from, I think, the writ of erasure fallacy, because they're thinking to themselves, I've declared this executive order or this rule or this statute unconstitutional, therefore it's effectively gone. No, it's not. Right? You're issuing a remedy that's directed at the named defendant. You're not issuing a remedy that's directed at the underlying law.
And you might say, not to put words in your mouth, but that you might have a different answer in an administrative rule.
True.
Where there's vacatur, right?
Yes, right. But again, that still has to be justified.
Yes.
So if you're going to argue for universal remedies in the context of the APA, you need to present a reasoned argument to the court for why the word set aside should be interpreted to mean vacatur, engage the arguments we saw in Justice Gorsuch's separate concurrence in the United States against Texas, engage the arguments in Professor Harrison's article, explain why you think they're wrong. This is still an open question in some of the courts. But you can't just go ahead and assume the propriety of a universal remedy. The assumption is what, to me, is based on writ of erasure thinking.
Excellent. So now let's talk about kind of your current work, and this is the part that I'm sure a lot of people are really interested in, I know I am, which is you talked some about how you came up with SB8. Could you talk about that a little more, and I think perhaps as importantly, how SB8 became reality? Not a lot of former academics can say that they have drafted a law that then had the nationwide consequences that did. So
it's a fairly long story. I'll try to give you a short version of it, but it actually began with a phone call I received from Senator Brian Hughes in, I think it was 2020, maybe it was 2019, where he had one of his constituents on the line who was trying to enact a local abortion ban in Wascom, Texas, which is on the border of Texas and Louisiana. And he had persuaded the city council to enact this local abortion ban. He was calling it sanctuary cities for the unborn. But the council was worried they might get sued by the ACLU. And they didn't want to have to pay out attorney's fees or even pay attorney's fees to their own lawyer. This is a small town. They didn't have a lot of money. So we got on this three-way call, and they asked me, is there a way to craft this local ordinance that can allay the concerns of the city council? Is there a way you can effectively enact an abortion ban in this small town and not worry about lawsuits from Planned Parenthood to the ACLU? And I told them, actually, there's a way you can do this. And just enact an ordinance that outlaws abortion, but just say in the ordinance that the city and its officials will have no role at all in enforcing it. It will be enforced solely by private citizens who bring lawsuits against those who violate it in state court. And if you write it this way, there's no way you can sue the city. I mean, you can try to sue the city, but we can throw it out quickly on jurisdictional grounds because you just say the city doesn't enforce the statute. Sorry, in this case, the ordinance. Just say, we have no role in enforcement, therefore we can't be sued. Wait until these private citizens sue you and assert your claims defensively. So Mark Lee Dixon, who was the activist who was proposing this idea in Wascom, presented the idea to the city council. I drafted it for him. And I told them, look, if you get sued, I'll defend you at no charge, right? Because I'm confident I can beat this back quickly. So you don't worry about having to hire lawyers if there's a lawsuit from the ACLU or Planned Parenthood. Let's enact this ordinance, see what happens. So we enacted it. Gets a little bit of attention. Washington Post wrote an article about it. A few other people did this. They showed the 5 city council members all raising their hand to vote for it. So it got some media attention, and then we waited to see if there would be a lawsuit, and nothing happened. So we did this in a few more places. Mark started to crisscross the state. He got these sanctuary city ordinances enacted in 5 or 6 other jurisdictions. Nothing happened. We finally did get a lawsuit from the ACLU, but they didn't challenge the abortion restriction. They said it violated the First Amendment. So they complained. So we just tweaked the ordinance to make that First Amendment claim go away, and they dropped the whole lawsuit. So this is, they obviously don't think they can challenge it. So Mark continues enacting these ordinances. He got about 30 of them enacted. This is all before SB8. The biggest fish was Lubbock, because all these cities where he enacted the ordinances, they had no abortion providers. Right. Then he goes to Lubbock. Lubbock actually had a Planned Parenthood operating in their city doing abortions. And he gets it on the ballot for a vote in May 2021. It passes by about 62 to 38. Planned Parenthood sues. Again, we have the same enforcement mechanism. Right. Goes to federal district court. District court throws the case out 3 weeks later for lack of jurisdiction because he says the city of Lubbock doesn't enforce the ordinance. You can't sue the city of Lubbock. So we already had basically a clean win in federal district court on this issue of private civil enforcement and how it can immunize, in this case, the city of Lubbock from a lawsuit. So we just, when the Texas legislature reconvened in 2021, Senator Hughes was asked to write the Heartbeat Act for the state legislature. And he called me and he pointed out that every state that previously enacted a heartbeat ban had failed in court. So I told him, we just do the same thing with your heartbeat law that we've been doing with these sanctuary city ordinances. We ban the state and its officials from enforcing it. It'll be enforced solely through private civil lawsuits. And then if the abortion providers try to bring a lawsuit over this, they're not going to have anybody to sue. So Senator Hughes incorporated that idea into the Heartbeat Act, and that was enacted around May of 2021. And then I think everyone knows the rest of what happened in terms of the litigation.
Were you surprised at kind of how much it exploded once that happened?
I wasn't surprised that it worked. I was expecting it to work. You know, in terms of...
No, I mean just like how much what a big national moment it was when that happened.
I knew it would be very significant if it succeeded, because it would essentially mean Roe against Wade, even though it hadn't been overruled, was circumvented. And once Texas did this, it would show the way for other anti-abortion states to follow its example, and essentially it would be the beginning and the end of the Roe against Wade regime. I don't think I was surprised by the reaction. I knew there'd be a lot of people who would not be happy about the fact that Roe had been circumvented and overruled, essentially de facto overruled by this tactic.
Were you worried that the Supreme Court would blink, that they would refuse to let this, that basically they would just be so upset about this machine that you built that they would change the law in a way that would do deep violence to federal jurisdiction and basic principles to try to do something about it?
I wasn't really worried about that because, for one thing, I wasn't sure what they could do. When the case got to the Supreme Court on September 1st, 2021, where this emergency request for relief was issued and sent to the justices, there was no way they could have issued an injunction that could have provided the necessary protection for the abortion clinics. There was only one judge who was a named defendant and one court clerk. So let's suppose the Supreme Court grants emergency relief and issues an injunction against that one judge and that one court clerk. What good does that do to the abortion clinics? They can still be... Texas has 254 counties. All right, so you took out one judge in one of those 254 counties. Great, we just won't file in that court. We'll file somewhere else. I don't know how they could have provided relief on September 1st, even if you want to give the abortion clinics everything they asked for. They asked for an injunction. Well, again, that injunction would have been useless. What if they had said in their order, we're hereby enjoining the law itself, which you can't do? Let's suppose they issue an order like that. We still bring the lawsuits because my clients would not have been a party to that case. They can't be bound by that Supreme Court supposed injunction against the law. And there's no such thing as an injunction against the law. An injunction operates against the litigant, not against the statute. So I didn't see any way the Supreme Court could have stopped or thwarted the act, even if they had given the abortion providers everything they asked for.
What did you think of the opinion that resulted?
The eventual opinion from Justice Gorsuch? Yeah, it was spot on. I mean, you can't enjoin a judge, from hearing a case. That's a patent violation of the Due Process Clause. If someone brings a meritless case in court, the judge should dismiss it. Right? And if the judge doesn't dismiss it, you take them up on appeal. The idea that you can go into federal court and you get an injunction to prevent him from even hearing the case in the first place, that's about as flagrant a violation of the Due Process Clause as I can imagine. You're allowed to bring a losing lawsuit, right? It doesn't violate the Constitution for someone to sue another person, even if the lawsuit turns out to be meritless. You just enter judgment for the defendant, and if it's a frivolous lawsuit, impose sanctions on the plaintiff.
Yeah, it worked.
Yeah.
So could you talk a little about, these are some of the matters you're handling now that I personally know a little less about. Mm-hmm. The first was Diane Hensley versus the State Commission on Judicial Conduct. Oh. What's going on with Ms. Hensley?
We had that argued about a week ago in the Supreme Court of Texas. Yeah. So Diane Hensley is a justice of the peace in Waco, Texas. And she officiates at marriages in her function as a justice of the peace. But she does not officiate at same-sex weddings for a variety of reasons. One of those reasons is same-sex marriage is still actually illegal in the state of Texas. This is writ of erasure fallacy, right? Obergefell does not change the laws of Texas. All Obergefell did is to say that we, the federal judiciary, will enter an injunction against state officials if they don't license or recognize same-sex marriages. Well, Diane Hensley is not involved in the licensure or the recognition of a same-sex marriage. She's just a wedding officiant. And she's also not deciding a case or controversy when she performs wedding ceremonies in her capacity as a justice of the peace. So she's still following the law of Texas. The Texas Constitution says marriage can exist only between a man and a woman. That has not been changed in response to Obergefell. So private citizens in Texas are not obligated to recognize same-sex marriages, and officiants are unobligated to perform them. They're welcome to perform them if they want to, but she's chosen not to. She's also invoking claims under the Texas Religious Freedom Restoration Act. So she's saying that as a Christian, she's not willing to officiate at weddings that go against the teachings of her Christian faith. So we've asserted that claim as well.
Does it matter that this is not part of her sort of core official duties? In other words, that it's sort of like she doesn't have to officiate weddings at all, even though she has the authority to. Is that relevant to the case, or?
Well, the other side's trying to make that relevant. But
I guess what I'm really
she has no duties. Yeah.
Don't officials sort of have to just apply the law as it exists when they're holding office?
Oh, sure, they do. Yeah. But the law of Texas still says marriage is between a man and a woman.
But the U.S. Constitution is the supreme law, so...
The U.S. Constitution is, do you think Supreme Court opinions are the supreme law of the land?
You tell me.
Well, I've looked at Article 6. I see the Constitution, the laws of the United States that shall be made in pursuance thereof, and all treaties made under the authority of the United States. That's the supreme law of the land. I do not see Supreme Court opinions on that list.
So if a Texas court refused to acknowledge a same-sex marriage, your point, I guess, would be what? The practical remedy would be federal.
You seek reversal.
Yeah.
No, if a Texas court says we're not going to follow Obergefell because we think it's wrong, the other side should just appeal, and the Supreme Court would reverse them. Presumably,
yeah.
Maybe they would. I don't know if the membership change would change their commitment to Obergefell, but the Supreme Court's opinion is binding on the judiciary in a legal realist sense, because if a court, when deciding a case, ignores Obergefell, they'll be reversed on appeal because the courts will follow Obergefell, right? Obergefell does not change the Texas Constitution. It does not change the Texas statutes that define marriage as the union of a man or a woman. If we were bringing this lawsuit in a state like New York, where same-sex marriage was legalized through legislation, or Illinois, or one of the Washington states, another one, it would be a very different type of case. Right, because you actually would have, same-sex marriage would be the law of that state, right? So now you're talking about a judge who says, I can invoke the Religious Freedom Restoration Act to not apply the law. That's a much more difficult claim to make. But when you're talking about a justice of the peace in a state that has still banned same-sex marriage and still defines marriage as the union of one man and one woman, she actually is following the law, right? She'd be breaking the law, in a sense, the law of Texas, if she went ahead and officiated at these weddings.
That makes sense. Another one I was interested to read about is George Stewart versus Texas Tech. So it read to me from the little blurb that I read that it's basically just it's like SFFA. I mean, they were not admitting. Yeah. So is that right? And if so, did you bring an equal protection claim?
Oh, yeah.
Or is it just Title VII?
No, we did bring the equal protection claim, and I think we're
as an advocate. Yeah.
Well, as exactly right. When you're an advocate, you have to make every reasonable argument on your client's behalf, whether you personally agree with that argument or not, whether you would accept that argument as an Article III judge. That's not the test, right? When you're in that advocacy role, you have to throw everything at the wall and see what sticks. Maybe not quite that far. You have to be. They have to be reasonable arguments. You can't make sanctionable arguments. But
how is Texas Tech defending this after SFFA?
Well, they wanted to wait for SFFA to come out, and we allowed them to do that. So they've filed their motion to dismiss. They're claiming we don't have standing. They're claiming some other things. Judge Hendricks will rule on that shortly.
It's a class action, though, isn't it?
It is. It has been brought as a class action, yes.
So somebody has standing.
Yeah. I mean, we'll see what they do. I think it's hard in the wake of SFFA to defend the continued use of race in admissions, but I'm not sure how they want to respond. And they have a lot of things to think about. I think they have to see not just what the university administrators want to do, but just how far the Attorney General of the state is willing to defend them in terms of the use of race or sex in these admissions decisions.
So the AG's office has to defend.
They're defending Tech, but they're not defending the other state universities. I don't know why they split the baby that way, but they did.
Interesting. Another one that I thought was interesting is Leela Green Little versus Llano County. And so, as I understand it, that's about a school or a library that removed some books, and the plaintiffs claim that was because of LGBTQ bias or something.
Yeah, the plaintiffs claim that. That doesn't mean it's true.
So is their argument that it violates equal protection? I mean, surely the library has the sort of plenary authority to decide what books they have. Right?
Well, there's only so much space on a shelf. You can't have every single book. Right? Librarians weed books every single day. You have to pull out the old books to make room for the new books, right? So when they make these weeding decisions, they base it on, is the book old? Is it worn? Is it being checked out? Is the book relevant to the community? There are all sorts of factors that go into these type of judgments that librarians make. So our librarian in the Llano County Library, she's weeding books. She pulled them off the shelf because in her judgment they weren't being checked out enough to warrant retention, especially when new books are coming in.
So what's next for you? I mean, what do you have planned for the next couple of years?
Yeah, continued litigation and then also legislation, just trying to tee up cases in the federal judiciary that need to be brought and hopefully brought to the Supreme Court once we get up there. It takes a long time for litigation to work its way all the way through the appeal process and to the Supreme Court. But then also just trying to advise legislators in Republican-controlled states on what they can do, and also better ways to insulate their laws from court challenge. We're still seeing a lot of laws being challenged in court that are being passed by Republican-controlled states, and we need to do more to rein in the federal judiciary and also some of these interest groups that try to tie up laws by getting these preliminary injunctions that we eventually get reversed on appeal. But as with the Heartbeat Act, I think there are ways you can just stop that from happening in the first place.
So I saw your name in a New York Times article recently on a list of people who might be good candidates to serve in the second Trump administration.
Oh, I didn't see that list.
Oh, well, I can send it to you after this.
Gee.
You're on the list. You're
gee. All right. I didn't know that.
Congratulations. You're on the list.
Okay.
Are you happy to be on the list?
Well, I don't know.
Is that something you'd be interested in?
What am I being listed for?
A generic, someone who could serve somewhere. And so I guess my question is really, would you have any interest in serving in the once and future president's administration?
Well,
and if so, what kind of jobs would you find interesting with your background?
It's a really hard question to answer now. We're still a year away from the election, and I don't know where I'm going to be in terms of my cases. One problem with going into government is I'd have to give up all the cases I'm litigating.
It's just you, right, at your firm?
Yeah. I mean, I can't hand them off to any law firm because no law firm wants to touch them. So I just don't know what that would mean for my clients. But I certainly would listen to offers. I mean, I would always be open to anything that's out there in terms of academia or government or who knows what. So it's very hard to predict how the next few years will unfold. I'm planning to continue my litigation and work on legislative issues, but I just don't know we don't know what the world will look like in 2025, just as we couldn't predict 5 years ago where we'd be now. So
certainly not.
Yeah.
So what advice would you have for kind of young lawyers or even college kids, who are interested in these issues about, what they should be doing, how they should plan their careers? Yeah. Should they plan their careers? What would you tell, 22-year-old Jonathan?
Sure. And things are very different now from when they were 20 years ago.
In light of career.
And certainly even when you were in law school 10 or 15 years ago.
Yeah.
So the big law firms right now are all exceedingly woke on every issue imaginable. They're hostile to conservatives, and I think you should look for career paths outside of big law to the maximum possible extent. And there are very good ones. There are good options. There are a lot of good boutique firms out there like Constable McCarthy and Cooper Kirk, and there's a lot of good opportunities in government and even at public interest firms. So just try to keep your options open career-wise, and to the extent possible, look for alternatives to big law. I hope we can maybe reform big law through lawsuits and through other ways of changing their incentives. I think a lot of the pressure is coming from their corporate clients in the C-suite. That's another big issue that needs to be addressed. But I think we're a long way from bringing about those reforms.
I agree with that part, for sure. What about academia? I mean, would you tell, again, a young version of yourself, but in today's world, to pursue it or not?
Well, I wouldn't want to tell someone not to pursue it because we really need good people in academia. And it's very important that we have people there who are generating ideas that other people can implement. So I don't want to discourage people from doing it, but at the same time, you have to be realistic. It's a lot worse than what it was 20 years ago. It's possible things will improve. I think with the ruling against affirmative action on student admissions, we can start using that to sue law schools over their faculty hiring, which is just, there's so much. White men aren't even brought in for job talks at many of these elite law schools, and that's even if you're liberal. If you're a conservative and a white man, I forget about it. So maybe that will change if they see a threat of lawsuits. Maybe it'll get worse. I don't know. Maybe they're going to double down. So
many of these schools are state institutions in red states. Mm-hmm. And so do you have any hope that, I know Governor DeSantis has done some stuff to try to kind of shake up higher ed when the state's footing the bill. Do you see any realistic prospect for that being meaningful at relevant institutions like, for example, the University of Texas, where I went to college, great school. It's in Austin. Senator Hughes, Right. We've been working on that in Texas. We passed a bill last session called SB8 that tried to reform higher education. It's a good start, but it doesn't do nearly enough in terms of what needs to be done. I think things will change if they start to fear lawsuits. And this is about everything, not just race preferences and sex preferences and the erosion of meritocracy, but also the assault on campus free speech, the fact that conservative student groups have their events disrupted and shouted down by protesters, university administrators do nothing about it. That's another problem that needs to be addressed. Private civil enforcement, to me, is the way to do it. So empower people to sue if their free speech rights aren't protected, empower people to sue if the university is subordinating meritocracy to diversity in any context, whether it's student admissions, faculty hiring, and so forth. And then start there and see what will happen. But I think once they begin to fear lawsuits, this behavior will stop. That's the key. We saw that with the Heartbeat Act. So if we can extend that idea to higher education reform, maybe we'll start bringing about some needed change. So maybe another SB8 for campus. Yeah, exactly. And other things as well. That's great. Well, thank you. I'm out of questions. It's good to see you. Thank you. Great. We're going to take you back to law school. Thanks a lot. Thank you. All right.